Welcome to the Estates Made Simple podcast with Jenna and Gordon Vanderleek. We are on a mission to simplify the world of estate administration, helping executors gain the knowledge required to manage an estate. Please note, the following is for informational purposes only and is not to be considered legal, tax, or financial advice. We recommend you seek individualized advice for your unique situation with qualified professionals. Welcome to another episode of Estates Made Simple. Gordon and I are very pleased to be here and talk about the exciting world of estate administration. I'm Jenna, and today's topic is about renouncing. We've discussed a little bit before about renouncing before you start taking on the role of an executor and before you start actually taking on the duties after somebody has passed away. But we wanted to talk about the process of stepping down after you've started acting. So perhaps you've made a few decisions in the estate administration and, for whatever reason, you've decided it's no longer appropriate for you to act and you want to go through the court process to step down and find another executor to replace you. So we're talking about today when you should consider stepping down after you started acting, as well as the process to follow. And that's really where Gordon's going to be talking about because he's done numerous files of helping executors step down after they've started acting.
Thanks, Jenna. It's great to be podcasting with you again. And yeah, it doesn't happen often, but it does happen, right? We both were talking before the recording of different instances where people, circumstance changes and you can no longer do what you said you were going to do. Yeah. So I like how you framed it to say it's once you're in the role, right? What happens in that circumstance? And so from your experience, what are some of the circumstances that give rise for somebody having to step down?
I would say, there's the financial circumstances as well as personal circumstances that could encourage someone to step down. So from the financial or the legal side of point of view, one is, the executor could be in a spot of a conflict of interest. Perhaps they are dependent on the deceased and want to make a claim against the estate. It's probably not prudent for them to continue on as acting as an executor if they're also going to be making a claim. So that could be one circumstance to consider finding another executor. Another, often case, which is very common in family dynamics, is if the executors do not get along and they're not able to make decisions to keep the estate administration moving forward. I mean, executors are held to a very high standard to be prudent and make decisions without delay and maximize the estate value for the benefit of the beneficiaries. And if they're unable to do that for family dynamic purposes, then, maybe one or both or all three in some cases should consider removing themselves from the situation. And another case, which I've been involved in, is executors have been doing a great job on the estate administration. But when it comes time to set up long-term trusts that will last decades into the future, they are not able to be around for that long. And so they want to have somebody step in and take over the trust component as it will last several decades, as I mentioned. And then from the personal side of view, if you're acting as an executor and you feel it's a heavy burden or you can no longer take over the role for health concerns, or perhaps you're moving or you're getting older, that's also another scenario that maybe you want to consider stepping down.
I think that's a good list. Thinking about recent experiences, I'd add to the list as well is that if there's legal challenges involved in the estate, one scenario that I'm dealing with now is where there's a will challenge. And one of the executors is also a beneficiary of a will that's under attack. And they're saying it's not a valid will. So everybody said, well, we need somebody else to step in. We need a neutral third party. So it's somewhat related to the executors don't get along or can't agree, but in a situation where it's necessary to bring an independent third party. So if you think of anything involving some sort of challenge or needing to get somebody in, then that's also a circumstance where you can make an application to the courts. Another thought, or what I see in the legal practice, is sometimes in a situation where somebody has done such a poor job of being an executor that there's an application to remove them because they're not doing well. But I think that's a little outside the scope of what we're talking about. This is where circumstances have changed. And what do you do in that circumstance? So maybe you can chat a little bit about that process is sort
Absolutely.
of the next step. So recognize in the circumstances here, there is provision under the law for this to happen. And so from time to time, this sort of application needs to be made to the court. But I guess the first point is you need to bring an application, right? You need to change it. And what you have to recognize is that you're changing the grant that's already been provided for the court, right? So we talked before about the probate process or appointing an administrator. If you're going to change that court order that was issued, giving the person the legal authority to start the administration, if things now change before the end of the administration of the estate, then a court order is needed to change that court order, if you will, if you think of it that way. So if you're going, well, why do you have to go to court? Well, because you're changing what the court has directed. The probate process, you end up with a court order. And so there can only be one grant to probate. So if you're amending the grant to probate, you've got to comply with all the rules. And the surrogate court will say, well, we need an order for that. And then they issue a new one, which will reference the court order that changed it. So there becomes a historical record that somebody was executor and now a new person is in place. So in Alberta, that would involve filing a C1 and a C2. Those are the forms for contentious estates. So an application with an affidavit. So you got to put that material before the court, explain what's going on, what are the reasons. And presumably, if you have a plan in place as to who's going to replace you, then the consent of that person, you obviously have to serve all the interested parties. So it's number one, you got to get a lawyer involved to make that application. In my view, that's there's a bit of complexity associated with that type of application. So that's generally seen as not a do it yourself project. You want to make sure it's done well. And for the person getting out, you want to make sure that your liability ends as well, right? Because you were on the hook until the court relieves you of that. So typically what you would do on that process will be also to do some form of an accounting. I mean, that's something to get some, depending on how long you've been in that role, the court may require as a condition of stepping down that you make a full accounting of what is being handed over to the new executor. And that would allow you to say you're discharged. And that's the comfort you have to know that no one can come back and say you did something wrong. So you would provide that record of the decisions that you've made and, what money's in the estate, what did you do with the property, what still has to be done, and then you can be discharged. So ending up with that, it sounds like a bit of a complicated process, and it is to some extent, but the comfort that you have for the person in the role is now there's a finality to it. There's an end to that process and some comfort to know, okay, now I'm done. Otherwise, you have those responsibility unless the courts discharge it. So you want to do that in a timely way because if you just stop doing the work of an executor, you could get into trouble of not doing something you're supposed to be doing, right? With that. So definitely legal advice is needed and maybe even involving a bookkeeper or an accountant to put together the record of the decisions, do that accounting so you can review those accounts. And of course, lastly, you want to serve everybody who has a potential interest. So that could include you may go to whoever the alternate executor is. So if it's relating to a will, you're going to go back and look at what did the will say if somebody can't do it any longer. And you would normally, that person would stand in line to replace. Do they want to do it? Are they consenting to this? Or are you proposing a new person? Or maybe the will doesn't have an alternate to you. In that case, you have to come with a plan and hopefully that person is agreeable to serve in that role. But you've got to be sure that you serve everybody who has an interest in the estate, all the residual beneficiaries or any other people who would have a claim against the estate might have something to say about who's managing the estate, right? So it could involve quite a few different parties and negotiating all of that. Obviously, if it's contentious, that's brings on a whole new element of time delay and expense associated with it on that, but that's the process you go through. So you would normally serve everybody with plenty of notice. You got to find available court dates. So it might take a couple months before
Mhm.
you end up in court, depending how quickly you have to move, but you have to give everybody adequate notice and then you got to find those people and serve them so they have an opportunity to show up and say their piece before the judge in making the final decision about whether somebody is relieved. If there's minors involved, maybe the public trustee has to be served, or somebody who's a represented adult. And so you got to look at the whole circumstances, understand the surrogate rules and the rules of court in general. So that's supports that conclusion that this is not kind of a do it yourself matter. Because if you fail to serve somebody, you may find, oh, you got to go back to court. The matter gets delayed. And now it takes longer to remove yourself. And that's not a good thing, right? If you need to get somebody in charge who's actually going to start administering and doing what they need to, because ultimately that's part of that accountability to the beneficiaries. So with that process, thoughts, comments on takeaways that you see in terms of the process I've described.
Well, I think that definitely highlights the importance of reviewing the estate before making decisions because it is so much easier to renounce before you start acting. But, just the process that you have to follow once you start acting is much more costly and time intensive. So that's one thing that sticks out. The other thing, too, and you've highlighted this, is the importance of seeking qualified and experienced legal counsel to help you through this process. Yeah, I mean, you wouldn't want to do it on your own. You want to make sure that somebody's there guiding your hand and providing all the necessary parties notice. So, yeah, it's just crucial for that experienced party to be involved.
Indeed. And yeah, I guess the other thing to add is if you're feeling like I'm getting closer to the stage where I'm not going to be able to do this anymore, I would say bring the application sooner rather than later. Like if you wait too long, think, well, maybe I can work it out, or things will get better. Well, that just gets you more in potentially into trouble. And it'd be better to say, well, let's have an end to it, so your liability is at an end, right? Because there is responsibility associated with that. So try to make an honest decision. Are you able to do it? Because you have to fulfill your court appointed duties,
Mhm.
right? You have those fiduciary responsibilities, and your job is to do them for as long as you can. And if you are being honest with yourself, saying, I can see a time where I'm not going to be able to do it, or I'm getting closer to that point, that's the point to start having these conversations. So it's not like you're doing it in a rushed situation, but you can do it carefully so there's the least amount of impact to the estate, right? So that the estate administration goes smoothly.
And
And
I
I guess
think,
that's sorry,
oh,
go ahead.
I was going to say, Lindy will cut this part out. And I think another important factor to consider is if you are exploring independent third parties, that process takes time as well. So I'm often engaged to go out to various independent third parties, obtain quotes, compare service proposals, which is then used for the court application process, showing that the current executor did their research and are providing viable options to the court
Yeah.
at favorable terms compared to other options. So I think that could also be supporting evidence and help along the application itself.
I guess two other thoughts. One would be part of that application would also be to approve any compensation that you would want for the work you've done so far, right? So
Mm.
then you can deal with that issue and wrap that up. But it also highlights the importance of the planning. Like if you're drafting a will and you're appointing somebody and you're going to go, well, what if they move down south or they become snowbirds and they're not around or they move out of country or something happens to them? It's always good to name alternates. Sometimes people on the planning side say, well, I've got one alternate. That's enough. Why not name several people in succession? Because you never do know, especially on the long term trust. We see that for disabled beneficiaries that trust could be around for decades, and the person you pick now just may get to a point where they can't do it, or something happens to them, right? And their
Mhm.
circumstances change. So you get to control that process. And I would always encourage it's better to list more alternate executors than fewer. So you ultimately have some control over who's doing this work, and your voice is part of that process.
Well, I think those are great concluding comments. Thank you, everyone, for listening today. Feel free to subscribe to wherever you subscribe to podcasts. If you have any questions or ideas for future episodes, feel free to contact us. We'd love to hear from you. We love talking about all things estate administration, and we look forward to chatting with you next time. Thank you.